welcome to Rightly Decided, the mostly originalist takes of the litigators of the Texas Public Policy Foundation. I'm Beth Latimer, and I'm here today with our Director of Litigation, Chance Weldon, as well as our special guest, and I'm going to butcher your title because no one in a C-suite has this title. You're the Chief Policy and Research Officer.
Correct. Hey, you got it right more times than Brian did.
I'm so excited for us. Dr. Derek Cohen. Derek, you are our policy guy. So today we are going to take a brief break from our rule that we don't talk about policy because we have our Chief Policy Officer here with us today.
But we're still going to talk about law stuff.
Mostly about law stuff. We're going to talk about the intersection of law and policy and how those things play together. So, Dr. Cohen, Derek, I'm going to call you Derek.
Please, just call me Dr. Cohen.
Tell us a little bit about your background and how you came to be at TPPF.
Oh, certainly. So I've been here just going on 13 years now. Joined when I was ABD, in the course of my PhD in criminology from the University of Cincinnati. And provincially enough, this position had just opened after I was down here for a wedding. And, you know, it was during that like the 2 weeks in the spring when Austin is like absolutely gorgeous and beautiful and not too cold, but also not too hot. And so, yeah, I came down and was like, well, I could definitely live down here. Unfortunately, then it became, summer. Yeah. But after that, though, the position opened and, like sand in the tent. They haven't been able to get me out yet.
So while you were in Cincinnati, there was an incident, I understand, at a place where you worked involving a gorilla?
I thought my agent said that we were never discuss this.
Never forget, Derek. Never forget.
we can't talk about that.
Yeah, so the incident you're referring to is, of course, the tragic death, not murder, but death of the beloved gorilla Harambe. Now, what people, and by people I mean Erica McHugh, who keeps this the legend going, usually fails to mention is that while I was at the Cincinnati Zoo for quite some time, and I was on the team that would have reacted should that have happened. My last day was about 10 years before that incident.
Okay, well, that's
yeah.
good
I've been working here for about 3 years when that happened. So.
That's exactly what I would say if I had killed Harambe.
But what did Harambe say about it? Guess you don't know now.
We'll never know. The world will never know. So another interesting title, in addition to potential Harambe killer, that you have is you are the Secretary of the Judicial Ethics Commission.
Oh, yep. State Commission on Judicial Conduct, yeah.
Yes, which is, I think, a black box to a lot of attorneys and even more so to just members of society in general. Will you tell us a little bit, before we get into some of the policy issues that we want to talk about, tell us a little bit about the commission. How does it function? How do you get, to the extent that you can, obviously. Sure. How do you get cases? How does it work?
Well, standard disclaimers up front. Obviously, every case that has been pending, or has been decided without any sort of public sanction is obviously confidential. Once and I'll go through the process here in a minute, but once obviously the punishment is met out and agreed to or not appealed, then that's when that case becomes public. So yeah, the State Commission on Judicial Conduct is a 13-member commission. It has 7 public members and 6 judicial members. It used to have 2 from the bar, but those 2 lawyers were then rolled into the public members. So the governor now would appoint as many as 2 attorneys to be on there. Obviously, all the judges are attorneys. If not, the commission's not doing a really good job. And then what would happen is somebody would refer a case, whether it's a case of criminal conduct off the bench or misconduct on the bench. And then we would basically have a range from the ability to dismiss it, I would say, all the way up to suspend somebody with a recommendation for removal or going into formal proceedings where the judiciary can actually remove that member. And so we're the body that does that.
So how does that work in Texas? Because I know, on the federal level, you have impeachment for misconduct, but judges are appointed for life and confirmed by the Senate at the federal level. In Texas, judges are elected. So how does this fit in with like concepts of impeachment or criminal justice? Like what exactly is going on with this commission?
So the judiciary, easy for me to say very fast, still has that ability. Oftentimes, though, it usually comes from a recommendation for formal proceedings. And I have to say is, these are very rare cases in which something like that actually, rises to the top. One of the more common things we see is like somebody that had not done their continuing judicial education. And so we say, hey, get right with your continuing judicial education. They go, oh, missed it, my bad. And
I'm sure judges love being told they have to do CLEs.
I would say judges don't like being told much, but no, we actually, and one of the points I have to make every time that I talk about ASCJC is that we have an extremely capable judiciary here in Texas at all levels. I mean, from justices of the peace, who a lot of folks say, oh, well, you don't have to have a degree, so they might see that as a lower rung of the judiciary, all the way up to our 2 Supreme Courts. I would say 99.9% of the judges are just absolutely top notch compared to what we see in other states as well. But it's like the joke I make about lawyers, where I say that it's the 98% of you that gives a 2% a bad name. It's the 2% of judges who are doing something wrong that are going to give the profession a bad name. And they also have to exist on a much tighter leash than, say, a political candidate. So like what they're campaigning, because you mentioned that they're elected, but even the way they campaign is highly, highly regulated by the judicial canons. And so once in a while, you'll see somebody who's part of a partisan, broad ticket, and that's not permitted by the canon. You can run with other judges. You can't run in a partisan race.
Can you unpack how that works?
Yeah.
I know they all run as, Republicans or whatever. So how does that work? What is too partisan for?
Long story short, it's somebody who's running and is either endorsing or I guess you can't stop someone from endorsing you, but if you were to use your office as an endorsement for a general election or primary candidate, because you'd say, if I were Judge Cohen and your candidate Chance, and I just said, Judge Cohen endorses candidate Chance, that is inherently partisan.
Mm-hmm.
Would it be the same issue if, for example, I mean, again, the judges are running in the party. If you were to say Judge Cohen encourages you to vote Republican this election, is that also a problem?
That would be. Now, here's the interesting caveat. I could say vote for Judge Chance, independent of party.
Oh,
but I can't. I couldn't say vote for a Republican Chance Weldon.
Oh, weird. So if he was running for county commissioner, you couldn't say vote for Chance. But if he was running for a district judge position, you could say vote for Chance.
Yes.
Interesting.
Even more interesting is I thought you were going to go county judge. And then I was like, that depends on whether or not they actually do judicial functions. And that's...
Oh, that's interesting too. And that's something that is, this is going to be a dumb question. How do we know whether or not a county judge has judicial function or not?
Well, honestly,
in the state of Texas?
That's a very good question. There's not like a central, I mean, obviously we have a roster of who the county judges are. There's 254 of them. But there's no, accounting for, well, this one retains judicial function, because they do get an extra stipend in doing so. This one retains judicial function, this one does not. What we'd have to do is that if a complaint that came in that we found that it was actually like a credible complaint, that then becomes one of the elements of establishing jurisdictions. We have to show that that judge does retain those judicial functions, and that it gets done through our investigators.
And how do your investigators function? Are they people that are hired by the commission itself?
Dealing with me, I don't know how they function, to be honest with you.
Can we just unpack that for those of our listeners? I know we have a very large Japan contingent.
That's true. We have so many overseas listeners.
So for people who aren't from Texas, can you explain very briefly how there are judges that aren't judges?
Okay, absolutely. So our county system, the way it's set up, or prefecture, our system, the way it's set up, is we obviously have a commissioner's court in every county, and then you have what is essentially your mayor of the county, to just keep it in municipal terms, which is your county judge. Now, the county judge obviously has a very broad administrative component. But if they, like traditionally, still retain some of the judicial functions, they do marriages or whatever the case may be, or some even sit in courts of law if they actually have the requisite judicial background. I'm sorry, the requisite educational background to do that. Then they can retain these judicial functions. And now, here's the issue, though. That's what gives the commission basically a I would say oversight on those judges, because otherwise the only cure for a bad county judge, a non-judicial county judge, would be an election, right? Mm-hmm. And so they are basically opting in to that jurisdiction by retaining those functions. We tend to see, especially in the larger counties, that's very, very rare in the larger counties. Mostly in the smaller counties will a county judge still actually be a quote-unquote judge in terms of our oversight.
And then in terms of like criminal law, are they able to take criminal cases if they are practicing law, or is that something that's still reserved for county courts at law?
That would be specific to the jurisdiction that they're sitting on, because I would say that's I never actually thought that one through, but it's probably one that it hasn't came up because it's just so uncommon for those both to coexist.
Much like the Railroad Commission doesn't do a lot with railroads.
Yeah.
Just because you have the same name as something doesn't mean that thing is what you are.
I would love to be on the actual Railroad Commission that if it did do like train
actual
gauges
trains?
and stuff. Yeah, exactly.
Like paying attention to where the railroads run.
I think there's a lot of people in this building that are very train focused.
Our producer's cackling back there.
I had a lot of Tylenol as a kid.
So I'm going to turn us, before we walk too far down that road, into some policy stuff, specifically something that has been of huge interest to you, Dr. Cohen. Civil asset forfeiture, or just asset forfeiture in general. First, I'm going to ask you two for a definition of it, because you two are far more qualified probably to define civil asset forfeiture than I am.
Then a former prosecutor?
Believe it or not, I never did it. We had a designated forfeiture prosecutor that was like, it wasn't all she did. It was like 1% of what she did. But like, I never touched the forfeiture issues. So
would have come up in your interviews.
It would have, and I would have said that this is not something that I do because I don't desire to be part of this. So tell me what it means and what your position is on it.
Sure. So in Texas, like several other states, we actually have in Chapter 59 of the Code of Criminal Procedure the entire structure of asset forfeiture. Now, it's actually deemed, and this is what one of the too clever by half thing, they go, oh, we only have criminal forfeiture. And it's like, well, yeah, but it's civil forfeiture, but you're just calling it different. It's like calling a county judge doesn't make him a judge. You see our earlier conversation. And essentially what it means is that absent a criminal charge or even a formal allegation of criminal conduct, that the state can seize, and then pending certain procedural hearings, should they prove to preponderance of the evidence, they can then forfeit, take permanent possession of that property. And we see it used a lot in connection with drug cases where the instrumentality of the item might be somewhat questionable. Like, for example, if a burglar gets arrested and you find glass cutters in there and we forfeit that, because not only is it, the tool of a crime, it's like a direct instrumentality of the crime, right?
Right.
But here with this, it's like, we're talking about like, oh, this guy had a truck, and maybe he
was driving his drugs around in his truck.
Exactly, which may or may not actually be the case. The thing is, we shouldn't necessarily be thinking about that. Well, especially post Timbs, if we're going to talk about a proportionality analysis, we should less be concerned about that. It's like, well, how about you stick the conviction for the drugs in, and then, should you wish to forfeit the truck, then it would be I guess that would be a Timbs question at that point. But.
Yeah, I mean, just to unpack that a little bit, I think where it comes up a lot, what distinguishes it from a traditional, say, criminal forfeiture, where it's the instrumentality of a crime, for example. What you would have is, maybe...
Or proceed.
Yeah, where the police pull you over, you have $5,000 of cash in the car with you, and they say, oh, we think that cash is suspicious, so we're going to take it. We're going to seize it. And then you can, through a forfeiture proceeding, have to show up and prove that, in fact, by a preponderance of the evidence, that cash is not linked to some crime in order to get your cash back.
Mm-hmm. And that is weird and distinct from criminal law, where the burden is always on the state. It is always my job to show that you have done XYZ crime.
Yep.
In the context of civil asset forfeiture, and why we call it civil asset forfeiture, is that it's a civil proceeding, and therefore the standard of evidence is actually lower, that preponderance of the evidence standard, to say it's more likely than not that this was in some capacity related to the crime. So the state's burden has been reduced in that respect.
Well, it's been flipped entirely, right?
So that's actually, because where does that 1% quantum fall on the line? And technically, yes, it is true that the state has to prove, beyond preponderance of that. But the thing is, then you'd have, well, what do you do in the case of a default? What do you do in the case of basically a lot of the procedural elements that kind of lie on the defendant or the accused, or not accused in this case, oftentimes side, does actually function as putting that that burden on there. Now, there's certain things where it actually is on the other side of that. For example, the one thing is, let's say that the underlying conduct is not in question, right? Like this person was using their car for distribution of drugs. Let's just stipulate to that. Let's say that car, though, is owned by grandma.
Right.
And if the car is owned by grandma, it's like the state's going to go take it. And that's like, well, no, now grandma has to show that, like, not only that she had no knowledge of that the car was being used thusly, she has to prove that up. Because otherwise they're like, oh, well, we pinched the kid on the drug charge, so let's just proceed with the forfeiture. Again, that's supposing that there actually is that alleged criminal nexus, which oftentimes there isn't.
So both of you have mentioned a few times Timbs versus Indiana. Walk me through a little bit of what that case held and whether that has anything to do with where we stand on it now.
Yeah, so Timbs was a case by our friends at IJ a few years back. Wesley Hot was actually the one who litigated that. Good friend from back. He's actually one of my first attorney mentors. Whenever I got out of law school, the first case I ever worked on was working with Wesley. It was not an asset forfeiture case, but he argued that case very well in the Supreme Court, and that dealt with a Range Rover.
Type of car.
Yeah, the plaintiff had been picked up for. I didn't know that I was going to be talking about Timbs when I sat
sorry.
down, so I'm like pulling it from the data bank in my mind. And so he gets pulled over and he gets arrested for possession with an intent to distribute. It's a small amount of drugs, I believe. And ultimately, what they do is they seize the Range Rover, which is, I think at the time, like a $50,000 car, and they forfeit it. And so this goes up to the Supreme Court on two questions. One, does the Eighth Amendment apply at all to the states?
So do we need some proportionality between the crime and the value of the Range Rover?
It's even worse than that,
okay.
Actually. So for those who remember, the reason the Bill of Rights applies against the states is the 14th Amendment. There was this idea, and there remains this idea, that the 14th Amendment incorporates the Bill of Rights against the states. That's your first 10 amendments. And over time, one by one, each of these, there have been cases that incorporate each one of these amendments. The First Amendment, the Second Amendment, famously in McDonald v. Chicago. McDonald?
Heller.
Heller was D.C.
Oh, that's right. That's right.
So McDonald was the one that incorporated the Second Amendment against the states, and you kind of adjudicate them on a case-by-case basis, and they come up. But, just a few years ago, the state of Indiana had argued, well, the Eighth Amendment doesn't explicitly apply to the states, and we don't think it should be incorporated. And they won on that below in the Indiana Supreme Court. So the argument the government was making is we can do all of the excessive fines that we want, and the Constitution doesn't have anything to say about that.
The 14th Amendment does not incorporate the Eighth Amendment, was their argument.
Yes, actually. It was
and they made that with a straight face?
They did. This was actually one of my favorite lines from newly appointed at the time Justice Gorsuch, who interrupted and said, "Counselor, it is 2018. Are we really arguing about whether or not the Eighth Amendment is incorporated against the state of Indiana?" So that was the first argument. And then that really ends up being what the court decides. It says, yes, the Eighth Amendment applies. It also applies to asset forfeiture, and therefore they sent it back down to determine whether or not taking the entirety of that Range Rover was proportional and therefore excessive to the crime of drug trafficking.
So it was one of those classic cases that we talk about all the time where the court decides a question and not a case and says, the question that you've asked is the Eighth Amendment incorporated against the states? The answer to that is yes, and you cannot have an excessive fine. We're going to send it back to decide the case, which is this actually an excessive fine?
Yeah.
And so that ended up going back down to the Eighth Circuit, I assume?
No, it was out of the state court system.
Okay.
So it had come up through the state court system. They had gone all the way through the Indiana Supreme Court, then to the United States Supreme Court, then back down to the Indiana Supreme Court, which sent it back down to the Indiana Court of Appeals.
Oof, that is a lot of work.
Imagine depreciation on that Range Rover.
Yeah.
Right? Yeah. By the time they finally get it back, it's like
it was
has
proportional.
No tires.
It was actually proportional.
So, all right, Derek, you for a long time had as one of your policy priorities civil asset forfeiture. And I'm assuming that means you're opposed to it, but also we tend to be a very conservative and to a certain extent back the blue organization. So how do you thread that needle of being opposed to civil asset forfeiture, but still, pro law enforcement to a certain extent?
Oh, yeah. I don't think those are, I would say, an intention at all. Most specifically is one of the things we've explicitly called for is for the police to be fully funded. And if you have to have part of the budget, whether it is a large part or a small part, contingent basically on what you go when you go fishing, what you catch when you go fishing, that's really no way to run a railroad or a commission thereof.
A railroad commission.
But yeah, so imagine, let's say, and we saw some really crazy cases, like I think it was Ferguson, Missouri, what came to light that something along like 80% of the operating budget was fines, fees, and forfeitures.
Oh my gosh.
So imagine that 80% of the solvency of a government function, one that we would argue is actually a primal government function, that basically 80% of that operation needs to be supported by, eating what you kill, or eating what you catch. And I don't know about y'all, but I've gone fishing plenty of times and I haven't caught where I haven't caught anything. And so that's not a way that you want to actually do that. And then on the backing the blue side, there are a lot of police officers and a lot of prosecutors even who just go, this doesn't seem right. Look, we use it in a drug case here or there. Was the person probably guilty? Yeah. But it's not worth sending somebody to jail over that, small amount, or putting them on probation for that small amount of drugs. So the punishment then is we're going to take the vehicle or whatever the case might be. But of course, the rejoinder to that is that's not, you don't get just, it'll come out in the wash in court, We have procedures for that.
Yeah.
Yeah, and I think to that point, just imagine the incentive structure. It creates, by not funding it through the legislative process, it creates a situation where your paycheck, your ability to keep functioning as a police department is contingent, at least in part, on seizing a whole lot of stuff and forfeiting a whole lot of stuff through this process. And so when you see that $5,000 sitting in the back of the car, or when you see that, Camaro or whatever that you can auction off, the implicit incentive structure that human beings just respond to is to use that tool that, where all of the standards are going to favor the government. And to use that to generate revenue. And that's not what policing should be for. I think good law enforcement officers don't want policing to be part of revenue generation. They got into that profession in order to protect their communities. Yeah. They got into that profession in order to keep people safe, not to actually be a vulture who's picking the bones of their community to try and generate revenue to keep their job. And I think that sort of the civil asset forfeiture as a regime creates those bad incentives.
And there are many ways to even to get around that incentive problem. One of the simplest one, and this was kind of pioneered in the North Carolina model, is you just basically have the proceeds of anything that is forfeited, civilly or criminally. And again, we would suggest criminal. Just have it go to a general fund where the actual police themselves don't get direct claim or direct dibs on that.
Yep.
And so that really, especially when we're talking about financial instruments, that tends to be the one that we see the really large amounts, and that's where we kind of have the biggest question marks about the propriety of it.
Can I make a point of originalist privilege, and maybe we can nerd out about pirates?
Please do.
But so the listener might be wondering how it is that property can just be taken without due process. It would seem to be that if you've not been convicted of a crime, that just taking your stuff might be unconstitutional, at least under the plain text.
It feels like we might maybe have a whole amendment that deals with this.
One might imagine, and certainly from a conservative perspective, if you care about private property and originalism and due process, you wouldn't want private property being taken by the state without just compensation or any form of due process. So you might be wondering where this came from. And it's one of these, Gorsuch and Thomas have both written on this over the years. It's one of these interesting sort of carryovers from history, and it has to do with pirate ships. So early on in the Republic, you would have situations where pirate ships, pirates would be captured. And of course, all the pirates would just abandon the vessel. Mm-hmm. And so now you just have this boat that's been captured by the authorities, and there's no one on it. There's no owner. And so what do you do with this boat? How do you deal with this? Because, no one's going to come forward and say, this is my boat. They're pirates. They'd be basically admitting that they want to be hung at this point.
Yeah.
And so they create this legal fiction that you would actually file a lawsuit against the boat.
Which is why you've got those silly case names like State of Indiana versus $42,000.32.
That's right. State of Texas versus one Chevy Silverado, right? This is why they're framed that way. It's a civil proceeding. It's against the actual vessel in this case, because it's, a vessel found in the open seas. And what's been really interesting is over recent years, as a matter of fact, I believe last term, Justice Gorsuch wrote separately as to whether or not our entire civil asset forfeiture system is constitutional because it's so far outside of finding an empty pirate vessel on the open ocean that it probably doesn't fit into that exception.
Yeah, you actually have a case where a lot of the owners are asserting their property rights over that.
Yeah. And a minute ago, Derek, you mentioned something that is a problem in this area, and that is default, which is, for our lawyers who didn't go to law school or don't have a doctorate.
For a lawyer who didn't go to law school, I don't know about that.
Yeah, our listeners who didn't go to law school. Default is when a lawsuit is filed and the defendant particularly does not respond to the lawsuit, doesn't appear in court, doesn't establish a right or assert any sort of right or defense. And in that case, the plaintiff just wins by default. That's why we call it a default. And a default judgment is established. So in a lot of forfeiture cases, or at least in some forfeiture cases, this suit is filed to forfeit this property and the defendant just doesn't appear, just doesn't show up. And then that property defaults to the government. So it sounds like, Chance, from what you're saying, that this process was established with default in mind. Like, it was established specifically for those cases where we're not going to have a defendant who comes and says, I want my property back.
I mean, well, at least with pirate ships.
At least with pirate ships.
Yeah.
The original system, back the way that it was during the founding.
I mean,
theoretically,
someone could have shown up and said, it's my ship and it wasn't used for piracy.
But it even has a little black flag with the skull and crossbones.
I abandoned it because I was having a bad day. I don't know.
I abandoned it because of the pirates.
The pirates took it over and I want it back now. But yeah, I mean, like you said, if those people came forward, they were asking to be hung, and that's not really what we're doing anymore, because usually we've already, I mean, at least sometimes, gotten that person for something and then said, hey, you had a small amount of drugs, now we're going to take your truck.
Well, now that we've incorporated the Eighth Amendment.
Yes.
Yeah.
In the year of our Lord.
In the year of our Lord, 2018. So this is one of those cases where we have had in the past this as a legislative priority for the Texas Public Policy Foundation. Was it something that we ever prevailed on or made a difference on or made a dent in?
Well, it had been part of our legislative agenda for at least 4 sessions that I can recall.
So 8 years.
Yeah, and it's not that we don't have a position on it now. Obviously, everything that I've written and my colleagues have written still stands on it. But we've actually found it's probably if it's not going to get changed legislatively, and I think that the legislature, at least collectively, has spoken for the time being on that there's going to be other routes by which to change some of this policy, notably like some of the work that y'all are doing, because, I can only beat my head against a brick wall for so many years, and then, the concussion starts building up. And
before we kick over to the courts, I mean, can you just, steel man the other side? I mean, I think for a lot of us that are lawyers and originalists, we see this and we're like, this is crazy. You can't just take private property without the sort of due process protections that we would normally understand. And there's, of course, all of these. We've talked about the bad incentive structures, et cetera. But what is the steel man of the other side at the legislature? Like, why has the legislature not fixed this?
Well, we don't have a whole bunch of pirates around now, do we? What I would say is the steel man of the other side. And the thing is, and this is not a completely inaccurate view, is that essentially this is a useful tool in crime fighting. And yes, it can conceivably use to get both proceeds and instrumentalities of crime off the street, so ergo less crime down the road. Again, but that tends to run into the brick wall of, well, why can't you do that within the confines of existing procedure?
Yeah, why can't you do that after a conviction, right?
Yes,
why
exactly.
Why do they do it in this civil proceeding that doesn't require a predicate of a prior conviction?
Nope, not at all. I mean, sometimes, even like I said, the allegations, you mentioned the point of the loose cash.
Yeah.
And of course, yeah. Well, I guess now they're probably trading in Bitcoins and stuff like that. But yeah, let's say someone has a quantum of loose cash on them and they're like, well, I work at a food truck or something like that. It should still not be incumbent upon the individual to prove a negative or prove that something does not exist, because that's almost impossible to do. And under the legal fiction that you mentioned, that's really the only way of going about it. I think that is probably the number one thing that actually does have effects in crime fighting, even though it's been studied to death and nobody's seen any remarkable depreciation in crime connected to civil asset forfeiture. Another one is the person's probably guilty anyway. And look, sometimes that is clearly the case. Sometimes you got to get Al Capone on tax evasion or something like that. But again, I would say that we don't have a system of law in courts and procedure in order to just hand wave away the due process rights that every American has been granted. And so I think that all of the steelmen for the other side tend to not survive their first contact with reality.
Yeah, I mean, just people don't have the money. If let's say you do run a food truck or something, and you have $3,500 in the car, and they seize it, and they say, well, come and file suit, get it back. It's going to cost you more in attorney's fees to get that money back, and they know that. So you just eat the loss, right? Your food truck, whatever it was that you made that day from your food truck, is just toast at that point.
Yeah, and you see that so often. We've actually had hearings in which people that have had their property forfeited just said, I had to put like $1,000 on a retainer, and I'm like, they're going, $1,000 on a retainer is actually not bad for a lawyer. But they're like, if it was for a trailer that was valued $700, why would I go in the hole for $300 just to get property back that I know was not used as a crime?
Yeah. And that, I think, is an important point that a lot of commentators miss when they're talking about this, because you see these big dollar item things that get forfeited. Like you and I were talking earlier, Derek, about a house that was like $1.4 million home that was forfeited over, some drugs that were being dealt out of a trailer in the backyard. Like these big dollar things that, of course, people are going to fight to get back. But the overwhelming majority of these cases are not big dollar things. They're the ones that make the news. But the majority of them are just like a couple $100 here and there. It's the roll of ones that are stuffed in somebody's sock. It's not the huge $1 million homes.
Let me yes on that, because that illustrates a whole separate and parallel point, is that at least under Texas law, we don't have provision for primary lien holders either. So, for example,
I didn't know that.
Let's say I go and get a new car, $50,000. I put $10,000 down, and so I'm obviously on the hook for 40 plus the financing costs. The bank could actually lose that $40,000 or 40 plus grand simply because are inadequate protections for primary lien holders as well.
That's interesting. So if I still owed $800,000 on my $1.4 million home, and it's forfeited, then the bank is actually short that $800,000. Wow, that's crazy. Are there usually provisions for that in the loans themselves? Like if for some reason this is forfeited, that the loan is still attached to the buyer?
Well, you definitely. Well, yeah. So I mean, the liability for the remaining money would then transfer to the. Well, I mean, they've still.
But now it's an unsecured debt, and what are we
default? Yeah.
What are we going to do? Yeah, declare bankruptcy.
Exactly, and so, but like that's one of the things, and you see that in all these like the horror cases where it's you have a kid who's living with grandma, and grandma has no idea what the kid's getting up to, and that gets used again. Maybe the house was used as an instrumentality. Oftentimes it doesn't need to be that, or a car. But then again, you still get that lopsided analysis of, okay, this person, was dealing drugs, and let's say was hit with a $500 fine. Yep. Does that justify the forfeiture of a $20,000 car? Yeah. And it's like, I understand it's not complete parity between our fine structure and property values, but at one point, or at what point does it get so out of whack that you're saying we're talking monopoly money here?
Right. Yep. Right. Especially because in Texas, the maximum fine for any crime, of any level of felony, is $10,000. As soon as you start talking about vehicles or homes or things like, you're already above our maximum possible fine for those criminal offenses.
And to hit that fine, you also have to have a conviction.
Exactly.
Or at least the plea.
Exactly. You have to have some sort of conviction to get that fine. So you're already talking about meeting that higher standard of proof and saying you have to show beyond a reasonable doubt that this felony was committed. Absolutely. Or this offense was committed. So this leads to, speaking of the judicial process, we've gotten a little aside of that, but the one time I think that you have sent all of the CAF attorneys in office a Teams message was to make us aware of this Alaska case, Joppy, versus
call
Alaska.
it because Joopy.
Is it like soupy or is it like choppy? I don't know. Joppy versus Alaska, which is a civil asset forfeiture case involving a Bush pilot's plane, a Cessna plane. Just as an interesting side note, this poor pilot is now 82 years old and he's been fighting this since 2012. So this case could very well outlive him.
Hard to get a case set in Alaska, I would assume.
Oh, yeah. Yeah. So he's flying his airplane. He has a 6-pack of beer. That's all that he's been found criminally liable for, was a 6-pack of beer, flying into a municipality that's a dry municipality. You're not allowed to have beer in this
And it was his
city.
passenger's beer.
And importantly, it wasn't his beer. It was his passenger's beer. But it was in plain view, I suppose, is what it sounds like. There's a lot of facts that have not been established in the media, is how I'm going to put that. They've been pled to different degrees by different parties, so it's kind of hard to know exactly what happened. But the gist of it is state troopers stop this plane. Do you pull a plane over? I don't know. How do you
marshal it to the side?
Stop
I suppose,
a plane. And they see in this plane a 6-pack of beer, and they decide to forfeit the entire plane for the offense of bringing beer into this dry municipality. Setting aside the question of whether
You don't hate local government enough.
this is a great example of that. Although it sounds like it was the state troopers that did the forfeiture. So you don't hate state government enough? I don't know. But yeah, so I was unaware of this until I got the 6 a.m. Teams message from Derek. Like, could this be the death of civil asset forfeiture? So I'm going to ask Chance now on the radio, on the podcast. Do you think this could be the death of civil asset forfeiture?
Affirm my priors.
Yeah, I mean, I look forward to Justice Gorsuch's dissertation on 18th century piracy.
Yes! We will all wear eye patches for that podcast.
Look, it's on the table. It's interesting that they took it.
It's interesting that they took it.
I think one of the things that was left open was exactly how to do the proportionality analysis. So to go back years ago, there was a case prior to Timbs against the federal government called Badgicasian that dealt with seizing, I think it was $30,000 in cash for failing to check a box on as the guy was getting on the air. You have to declare the amount of cash that's with you getting on an airplane. And they took like $30,000 worth of cash as a forfeiture for failing.
And importantly, that was the only crime.
Yes.
Was that he did not declare it correctly.
Yes.
Yeah.
And there was a split on the court. Justice Thomas writes the opinion. He joined with several of the liberals, but I remember Justice Scalia was in dissent in that case. And Justice Thomas said that under the Eighth Amendment, this was grossly disproportional to the crime. He gave some factors where you look at like what the maximum criminal penalty was for the civil forfeiture. And that was held to be unconstitutionally excessive. The courts have really struggled to understand how that works. Like what
How do we apply this? Yeah.
Yeah. And so it'll be, I think the guidance, I think that's probably what they're taking a run at. There was also another question that was left on the table in Timbs from Ginsburg's majority opinion, which is going back to Magna Carta, there was special protection for the implements of your job. Like seizing the implements of your job were considered
seizing a car if you're
right, like
someone dependent on your vehicle for
So I think the example they gave was like if you were like a blacksmith and they took your anvil, right? That's actually how you feed yourself. So that was a special kind of forfeiture. So that issue might be out on the table as well. Not only did they take this guy's plane, which is $90-something thousand for having a 6-pack of beer, but it was also the way that he feeds himself. And so it'll be interesting to see if that actually becomes an official part of the Eighth Amendment test as well. So do I think that this will be the one that finally kills asset forfeiture? Not based on the question presented, but I think we'll start getting some more rumblings about that again from Justices Gorsuch and Thomas at least.
Do you think we'll get some interesting dissents about the originalism behind having dry cities and dry counties and whether or not that's actually something that falls within the police power?
Well, I think after the 21st Amendment, they're going to say that the Constitution expressly gives states authority to regulate alcohol. And so I think that's probably off the table. They wrote on that in the Tennessee Spirits case a few years back. It was a dormant commerce clause challenge. I don't think that'll come up.
So probably not so much. It's an interesting question, but this one's going to be a battle more about the plane, I think, than the beer.
How much does a 6-pack of beer compare to the tankard of hard cider that John Adams drank every morning with his breakfast?
I think we'd have to Google what a tankard is before I can answer that question.
Research is part of my portfolio. So
there you go. Please find out how much a tankard is. And then in my honor, drink a tankard of cider with your breakfast tomorrow
Anything
morning.
but the metric system.
Anything but the metric system. So we talk a lot on this podcast, Derek, about making Congress do its job and the problems that we see so often arising and the frustrations with the judiciary come from the fact that the legislature, not just Congress, the federal legislature, but also our state legislature, to a certain extent, just hands off, we're not going to touch this. And as a result, the judiciary sometimes has to step in and solve these problems. It is part of your job to try to make the legislature do things. So how do you, in your job here at TPPF, try to make the legislature do things? What does that look like, turning policy into law?
Yeah, well, that's a great question, and yeah, I mean, we did have some success at the federal level back in 2018 with the First Step Act, which I can tell you, versus talking about policy at a state level, doing it in Congress is a completely different game, and it's much harder, and it's horrific, and I would not recommend. 0 out of 10.
0 out of 10.
But here though, we have citizen legislators. They are part-time legislators, even though with special sessions they're around a lot. But they all have day jobs, and so they are actually doing this in a very spirit of Cincinnatus vibe. And so they, at least I find, and that's not to say they don't have policy preferences. That's not to say that they don't have political priors that need to be assuaged. But they generally come to this, even the ones that disagree with you, from a place of wanting to have the best Texas for everyone out there. Now, what that best Texas looks like, that tends to differ based on party and region and stuff like that. But essentially, our role as a 501c3 is to take these ideas that are consonant with what it is we believe and essentially do the supportive research that shows that this is a better idea than the alternative or no action at all, and then say, look, here's the case is a persuasive, or here's the persuasive case, and then we say, and if you were to make this a bill, we would probably structure it thusly. And anything we can do to support y'all in that, best of luck. And so we actually work across the aisle pretty well with a lot of folks on the left and the right, depending on the issue area, because so much of, I would say, the motivation for getting the policy right is shared. Now, again, does that mean the most progressive member of the Texas House? Are they finding a whole lot of stuff at TPPF that they would really love to raise up the flagpole and call a victory on? Not necessarily, but I remember we've had multiple Democrats coming in here for mostly David Dunmore's podcast, so we can blame him.
He's our tech guy, right?
Exactly.
He's our tech guy.
But great example with Nathan Johnson, Senator Johnson, was the Senate author of the data broker bill. Mm-hmm. And that really kind of moved Texas towards seeing data privacy as the virtue rather than the promulgation of data as the virtue. And so sometimes you have odd bedfellows like that, but that's essentially the route. And then obviously our experts go up and they'll testify on whatever the particular question is. And so, back in the day when I was with Right on Crime, I used to testify on civil asset forfeiture, bond issues, and everything from sentencing to drugs to everything else. And so, yeah, that's kind of how we do that. We do all the research in-house. Sometimes we have to contract out if we just don't have the niche expertise in some areas. But then we do all the bill generation in-house, and we do everything else up there at the legislature.
Lots of graphs, some math.
Of graphs.
Oh, not in public. We don't do math, but you do math in private when you can get it wrong, and then
I don't know. I have seen the scribblings of Brent Bennett.
Yeah,
the man can do math so fast.
He's a special case. I
remember when I started here, there'd be questions about like folks wanting us to testify on a bill or something, and we don't do that. I've only been down like twice. But
we being CAF. CAF doesn't do that. TPPF
does that all the time. But one of the things that I thought was really cool was, I remember at the time hearing folks say, well, we can't testify on that because we don't have any published research on it yet. Mm-hmm. Like we haven't actually done anything to put data in that, and therefore we won't testify on it. Mm-hmm. And so tell me just like a little bit about that process.
Yeah,
how do we decide what it is that we're going to go opine on?
Yeah, well, that's a really good question. So obviously, our tax status is dependent on us having verifiable independent research that supports whatever it is we eventually position we take on something. Because absent that, you're just an advocacy group, right?
Yep.
You're just basically you're no different than sadly what the ACLU is nowadays. But what we do is we have what's internally known as Policy Council. And it's a multi-member body internally that will whenever a new idea gets brought up, it goes before Policy Council. And I think you might have did a Policy Council or two. And then I would say the proponent of whatever that bill might be, or I'm sorry, whatever that idea might be, because an idea can lead to multiple bills, or it would take multiple ideas leading to one bill. But whoever is the proponent of that basically just gets raked over the coals. Like, the absolute stuffing gets kicked out of the idea. And we have some fairly serious and some fairly, I wouldn't call it contentious, because we all, good faith discussions as colleagues. But we have some pretty serious debates on that. And where original principles are brought up, where, feasibility is brought up. And then even things like, is this juice even really worth the squeeze? And unless you can really answer all of those in the affirmative, it usually gets left pending. And so there are 4 members on the Policy Council, 3 of which have to agree with you. Then it advances on to the big man upstairs. And by that, I mean Greg Sindler. And then for it to become a formal part of our agenda, then it needs assent from the board. But for the minor items, we still need that Greg hurdle as well.
I think it's interesting the extent to which your job relies on a presupposition that truth is knowable, and that with research and due diligence we can discover what the truth is and work towards the truth. And there's not really a question in there. It's just kind of an observation, and something that I really appreciate about the job that our policy team does is just that position that we can know what the truth is, and we're going to go find it out before we try to make a policy argument.
And let me yes and that. And I would say it is uncommon, but it's not unheard of, where we actually find an idea and start down the path of researching it, and like kind of start to form we should do this or should do that. And then as the more the research comes together, go, oh, wait a minute.
Oh, maybe we should not.
No, we can't do this. Whether it's a legal argument, like the state literally does not have the authority to do this. Yeah. And so speaking right to my buddy Chance here, or it's something that we just don't have the technical complexity of whatever institution or apparatus within the state that would do whatever it is we're discussing. Yeah. That sometimes we have to remove something that way. And like I said, it's not common, but I would say the largest cause of that is usually state-federal interaction, and where it says, oh, isn't that a Fed thing? And they're like, I don't know, I guess we got to look. So,
Yeah, absolutely. I know it's not uncommon for your policy analysts and policy scholars to come up to the 5th floor and ask the lawyers, hey, is it constitutional if we, and sometimes the answer is, no, please put that back in its box. That's not no.
Well, I'm going to go ahead and say every good idea that got brought to you is because of my leadership has facilitated, and every bad idea, they're going rogue. So
Exactly. All right. Well, Derek, thank you so much for coming on today and for joining us. This has been a super fun conversation. Chance, thank you for being here. And to our listeners, we hope you enjoyed our conversation. If you did, please leave us a review and join in next time for more Rightly Decided.